Good afternoon. I'm Harold Kent. I'm the Dean of Chicago Kent. At least I know many of you here, and I'm delighted to welcome you here with us today. An alumnus named Roy Palmer approached me right after 9/11 and said, you know, the whole theory of how we try to reconcile civil liberties and the war on terrorism has been under-theorized. What we need to do is have an incentive to have more people think deeply about how we try to preserve liberties in an age of where the idea of war and the idea of terrorism has changed so exponentially. Now, some, of course, immediately said there is no need to reconcile, that the way to prevent terrorism is just to enshrine civil liberties more deeply into our firmament. I don't think that is held up with the test of time. And so we need to think about structures, mechanisms, because there is slippage in international law, slippage in the concept of alienated slippage in terms of our own understandings of surveillance and civil liberties in our own country. Sort of by happenstance, last night David Cole gave a talk on drone strikes, a new sort of form of tension in the war on terrorism. And David Cole was, I think, the first recipient of the Roy Palmer Civil Rights Prize for his work on understanding the war against global terror. But we want to thank the Palmers for their initiative in trying to shedding more light into this very important role, and the Palmers are very unhappy, if you will, or that they took ill and were not able to make the trip to Chicago to be here today. I know they were very excited about meeting the recipient, Susan Herman. Susan Herman has been president of the ACLU since 2008. She's the Centennial Professor at Brooklyn, and she's focused much of her life, recent life, on the question of civil liberties in an age of a war against terror. But of course, her interests and those of the ACLU are much deeper, and indeed, we just talked earlier, there are 6 cases in the Supreme Court this term directly litigated by the ACLU, and a wide number of other cases in which the ACLU has served as amicus. So with that, I'm delighted to welcome Susan Herman for her book, so I get it right, which is Taking Liberties, the War on Terror and the Erosion of American Democracy. And if you're interested in Twitter, the hashtag is Palmer12. And with that, Susan Herman.
Thank you, Dean Krent. It's a pleasure to be here today with you, and I'm extremely honored to receive the Palmer Prize. I have unfortunately never had the pleasure of meeting Roy and Susan Palmer, but I think that our thinking is certainly compatible, so I'm so sorry that they couldn't be here with us today so that we could test that proposition and have them be part of the continuing conversation that they have been promoting. So I think that the reason that I wrote this book is really very similar to the reason why the Palmers decided to fund this prize. And I think I want to start by telling you the opening anecdote in the book, because you're entitled in any speech to have an opening anecdote. So this begins after I was president of the ACLU, and I was at a professional dinner seated next to a woman who I think you will see was not an ACLU member, but she was well schooled in the social graces, so she knew that you talked to the person to the left of you and the person to the right of you. So she turned to me and said, "So, tell me what the ACLU is doing lately." She said, pause, "but don't tell me about that Guantanamo stuff." She said, "I'm so sick of hearing about that. Why should I care about those people anyway? They're not even Americans." So, gasp, right? So I gasped, and then I tried to explain to her why I thought, agreeing with David Cole, we really should care about those people. But she was having none of it, so we went on to talk about other things. In fact, I told her about the breast cancer suit that we have in the Supreme Court currently, and she said, "Oh, no, that's important." But I decided that, part of the problem here was that she thought that the whole war on terror had nothing to do with her. So I wrote the book in order to talk to this woman and other people like her to explain how the changes in our law since 9/11 in fact do have and can have a tremendous impact on ordinary Americans. So what my book is not about is it's not about Guantanamo and targeted drones and torture. David Cole has done a great job writing in all those areas. But my book is about all the ways in which the changes in law post 9/11 do have an impact on ordinary Americans and our rights. And just for a list, we'll read you the part from the introduction after I talk about my opening anecdote. I said that she's wrong if she thinks this doesn't affect her. She could be one of the hundreds of thousands of innocent Americans the FBI has been spying on using the broad net of the Patriot Act and supplemental powers. Her banker and her stockbroker, among many others, have collected financial and other personal data about her to lodge in government data banks, ready to trigger an investigation of her if the government happens to connect some dot of information to her dots, even if she's done nothing wrong. Her computer geek neighbor might be one of the innumerable telecommunications workers and librarians whom the FBI has conscripted to gather information on hundreds of thousands of occasions, perhaps about her friends or acquaintances, and then ordered not to tell anyone anything about their experience on pain of criminal prosecution. Her nephew could be the computer studies student prosecuted for providing, quote, material support to terrorists, a crime punishable by up to 15 years imprisonment, because he served as a webmaster for a website posting links to other people's hateful comments. Her son could be the college student detained and interrogated for packing his Arabic English flashcards to study during a plane flight. She could find herself unable to complete an unimportant business or personal trip because her name was incorrectly placed on a no-fly list, or simply because she has a common name like T. Kennedy. Her favorite charity could be shut down for years or even permanently because a government bureaucrat once decided to investigate it even if the investigation went nowhere. Her generous contribution toward humanitarian relief might be sitting in government escrow for years instead of reaching the intended recipients or being returned to her. Her doctor's assistant could be the young Kashmiri American who was stopped and searched in the New York City subways on 21 separate occasions, even though the odds of the same person being selected for a, quote, random search that often are 1 in 165 million. So there's a little bit of an introductory panorama for you about the extent of the ways in which our laws have changed after 9/11. Now, I think one reason why this woman had no interest in and no patience in hearing about all that Guantanamo stuff is that, first of all, she thought all this had nothing to do with her. And I think many people share that assumption, which is, again, one of the chief reasons why I wanted to write the book, to try to share information about what actually is going on that most people aren't attending to. A second reason why I think that a lot of people aren't so worried and not that interested in finding out more about all the things going on is you hear people saying, and Dean Krent's introductions that have referred to this, don't we have to give up a little liberty in order to be more secure? Well, I think a second problem here, and this gets to why should I care about those people, is that most of the people who you say, don't we have to give up a little liberty in order to be more secure, do not expect that it will be their liberty that they're giving up. They expect that it will be someone else, those Arab and Muslim men. And finally, these days I think a lot of people have relaxed because we now have a different occupant of the White House. When Barack Obama was elected and George Bush left the White House, a lot of people said, isn't that it? Aren't we fine now? And people were basically suggesting, well, could the ACLU go out of business and perhaps put up a nice sign in front of our office saying, mission accomplished? Well, premature as always. So it turned out that although Barack Obama did take a very different tone as to Guantanamo and torture and all those issues about those people, almost everything that he has done in the sphere of domestic national security policy is the same. And his positions have really switched quite a bit when he went from being a candidate to being the president. So I want to talk briefly to you mostly about two areas in which the laws have changed. And I dare say that even though this is a very sophisticated group of lawyers, law professors, law students, I would be willing to bet that there are things here that you just didn't know about and things that you're going to find surprising, perhaps shocking. So one of the areas that I want to talk to you about is the area of material support laws. One of the common themes after 9/11 was this whole idea of what do we need to do to be safe? What if there's a terrorist and we can't find the terrorist? We have to do more surveillance to find the terrorists. What if there's someone we think is a terrorist, but we can't prosecute that person because we don't have enough evidence to convict them of a crime? Well, this thinking is it's dragnet thinking. We need to have a bigger dragnet to make sure that people don't escape whom we suspect. So one of the first dragnets that was laid out in the criminal law itself were revised material support laws. Now, the material support laws first entered the United States Code in 1994, and the basic idea of a material support law is it's to expand the ability of criminal law to prosecute people who are suspected of being connected with terrorism if we don't really have a completed act or something that we could otherwise prosecute them for. So the first material support law said that if you provide assistance, weapons, cash, something like that, to a terrorist organization, you can be prosecuted for providing material support to terrorists. Well, when you think about that, most of what's wrong with that, if you provide bombs to a terrorist and then they kill people, or you give them money to buy bombs and then they kill people, you could be prosecuted for murder, conspiracy, attempted murder. There are all sorts of things you could be prosecuted for. So the idea of the material support laws was to push back in time when you could prosecute somebody for a crime, even if you could not show that either harm had been affected or that you intended, because if the government could show that you intended your contributions to be able to use to kill people, you can be prosecuted for conspiracy, attempt, etc. So that was the first idea. This initial law in 1994 had two very important carve-outs or exceptions, one of which was for humanitarian assistance. If you gave humanitarian assistance to somebody who was suspected of being a terrorist or a terrorist adherent, who was not directly involved in violations, that was considered to be a defense. So if you were the Red Cross and you were giving aid to people in, say, the part of Sri Lanka that was being run by the Tamil Tigers at the time after the tsunami, you could not be prosecuted for providing humanitarian relief under the material support statute. That's one exception, the humanitarian exception. The second kind of exception was a carve-out for First Amendment-related speech and association. So what that said was that the government could not initiate an investigation on you on the basis of First Amendment protected activities, like your speech or association. That was the 1994 law. These begin to look like in baby steps, and a lot of this, the laws has been very incremental. In 1996, after the Oklahoma City bombing, an example of domestic terrorism, as a response, Congress passed the Anti-Terrorism and Effective Death Penalty Act of 1996, commonly referred to as AEDPA, which President Clinton signed into law. Now, AEDPA had a number of different sections, but the section that's relevant here was that this statute amended the material support law by providing that it is not necessary in prosecuting someone for providing material support to terrorism to show that they actually intended to have their support used for any terrorism, or to even show any actual connection between your material support, your contribution, and terrorism. The theory here is that money is fungible. So suppose that there is a nursery school that's being run by Hamas. Hamas, assuming presumably a designated terrorist organization. If you contribute money to the nursery school, the theory goes, even if you have no intention of supporting the terrorist activities of Hamas, that frees up resources of Hamas for them to use in terrorism examples, because now they don't have to pay for the nursery school. So that was the theory of AEDPA, is distancing all this a little bit more. After 9/11, the Patriot Act further expanded the material support laws in several different ways. Number one, it expanded what would be considered to be material support to terrorists. In addition to the more obvious things, if we're giving the terrorists guns or money, they added some very vague categories. If you're providing personnel, if you're providing training, or if you're providing, the broadest category, expert advice or assistance to terrorists, then you can be prosecuted for material support. The Patriot Act also very much narrowed the two exceptions that had been in the original material support law. The first is that it pretty much eliminated the exception for humanitarian aid. They narrowed that to it's only if you were providing medicine or religious books that you would not be considered to have provided material support to terrorism. You can give them a Bible or a Quran, you can give them medicine. Can you give them medical assistance? No. Anything like that would clearly be considered expert advice or assistance. And therefore humanitarians no longer have the excuse of, well, okay, we're treating the terrorists, but we're doing it for humanitarian reasons. The idea was the terrorists are supposed to be radioactive. Nobody is supposed to go near them at all for any purpose. The second thing that happened was that the First Amendment exemption was removed. The government now can begin an investigation on the basis of free speech or activities that would be protected by the freedom of association, or, as you'll see in a minute, the exercise of religion. One thing that the 9/11 Commission commented on was the ability to use dragnets like this for religious profiling. And the first story I want to tell you about what's wrong with the dragnets like this concerns a young man who was a graduate student at the University of Idaho named Sami al-Hussein. He had come to study computer studies, And after 9/11, he led a candlelight vigil. He was the head of a Muslim student association at Idaho. And he led a candlelight vigil expressing concern for the victims of 9/11 and trying to tell everyone on campus that this was not what Islam was all about, and people should not get the wrong impression. Consistently with that idea, he became webmaster for a group that was called the Islamic Assembly of North America, not a group that was ever suspected of having terrorist connections. It's just a group of people who defined their mission as promoting a proper understanding of Islam. Now, to be fair, what this Islamic group did was they posted on their website all sorts of information about Islam. Things written by moderate Islamists who wanted to say, we just don't agree with the terrorists. But they also posted some links to things that jihadists said about why they did what they did. They were just trying to promote education and conversations. Well, Sami al-Hussein, because of his expertise in computer studies, became webmaster for this group. And therefore, he posted links to all sorts of different material. Evidently, the way that the government agents first became interested in him was that they were studying the records of his financial contributions. Pause, that's something that the Patriot Act allows them to do and various other federal laws. One dragnet is, in order to find out who the terrorists are, the theory of the fall of 2001 was, well, maybe what's happening here is that Al-Qaeda is being supported by contributions made in mosques in Brooklyn. And therefore, we better find out how the money is traveling through the terrorism pipeline and stop it. So there was really a witch hunt in the fall of 2001 against Muslim charities. And anybody who donated to a Muslim charity was considered somebody you might want to investigate. Now, it's obvious to us, of course, that there are millions of Muslims around the world who donate to charity because that is a tenet of their religion. And of course, the vast majority of causes they contribute to have nothing to do with terrorism. Well, Sami al-Hussein was a member of a fairly wealthy family, and so he was making some fairly large donations on his own behalf and his uncle's to various Muslim charities. The government ended up prosecuting him, and one of their theories was that he was supporting a terrorist group. But the evidence that they had was so shaky that what terrorist group it was kept changing during the course of the prosecution. First they said he was supporting Al-Qaeda. Then they said, oh, never mind that, he's supporting Hamas. Then they said, oh, never mind that, he's supporting Chechnyan rebels. Okay, but the assumption was, it's like this assumption of guilt. He's giving to a Muslim charity, therefore there has to be a terrorist at the other end someplace. So the prosecution rested for material support of terrorism on the idea that what Sami al-Hussein was doing was posting links to different websites that might enable readers of those links to decide that they also wanted to support Al-Qaeda, never mind Hamas, never mind Chechnyan rebels. And therefore he was promoting terrorism. Sami al-Hussein ended up spending 17 months in essentially solitary confinement waiting for his trial to go on. And while he was incarcerated, his family was deported to Saudi Arabia. The government had originally agreed to let the family stay while his trial was going on, but then the trial was postponed, and they ended up being deported. So this, of course, was a pretty terrible experience that he had. His lawyer argued to the jury, essentially argued the First Amendment. His lawyer first tried to argue to the judge that this prosecution was a violation of the First Amendment. And one of the things that the lawyer argued was that if you can prosecute this graduate student for posting links on a website to somebody else's hateful speech, then you could also prosecute CNN for broadcasting any terrorist explaining their position, or the New York Times, which had run an editorial by a member of Hamas explaining their point of view. First Amendment is supposed to not censor what information we get. It's supposed to allow us to get all the information and then make our own decisions about what we think, broad range of activities. Well, when the lawyer, the defense attorney, asked the judge to dismiss this prosecution on First Amendment grounds, the judge denied the motion, and he said an opinion will follow. Well, the opinion never followed, and I think wisely, because it would have been a very difficult opinion to write in the mid-2000s. What was interesting in this case, and you may regard this at least in part as a happy ending, is that the jury was asked to think hard about the First Amendment. And they were given a crash course in the First Amendment, and they decided that it was just wrong to prosecute somebody for sharing thoughts that people might disagree with. And they really got that if you could prevent Sami al-Hussein, where would that stop? So the jury ended up, amazingly enough, acquitting Sami al-Hussein. Okay, happy ending, but this man spent 17 months in solitary confinement. He's now back in Saudi Arabia, where his lawyer tells me he spends a lot of time pondering how he can put together the fact that he always viewed America as the fairest and most just society on earth with what happened to him. And he just doesn't want to talk to anybody. I didn't get to talk to him in writing my book because he just, he's just trying to put this whole episode behind him. So a lot of other stories in the book about what happened there on the Idaho campus where the FBI comes storming in at 4 in the morning because they believed that they had found a sleeper cell in Idaho. And they were wrong. Okay, now people make mistakes, but to me part of the problem here is that this isn't just a mistake. It's a mistake that's encouraged by the breadth of the law, that's allowing the government to focus on anyone who's contributing to Muslim charities, and the material support law, which in fact allows focus on people who are contributing any sort of expert assistance or advice to people who are suspected as terrorists. Second example, the humanitarians. There is a group called the Humanitarian Law Project. Any of you familiar with the Humanitarian Law Project versus Holder case? Okay, a couple of people. What the Humanitarian Law Project were doing, they're a group of peace activists. And what they do is they go around the world and they look at places where there are civil wars or potential civil wars or insurgencies, and they try to train the people involved to resolve their disputes through nonviolent means. So they work, for example, with the Kurdish rebels, who have a lot of complaints about how they're treated by the Turkish government. And what they tried to do is to try to tell the Turkish rebels about resources that they would have working through the UN, and through international human rights law, and Congress, etc., to try to promote the idea that maybe the United States should be coming down on Turkey about these violations and just encouraging them to use peaceful dispute resolution methods instead of violence or terrorism. Well, they started to worry after the law was changed in 1996 in Enfa, which talked about, you don't get exemptions just because you're humanitarians. If you're providing personnel or training to terrorists, it's a problem. So they brought a lawsuit. David Cole was actually one of the lawyers in this lawsuit, starting in California, which ended up involving over a decade of litigation about whether or not this statute, number one, would cover the Humanitarian Law Project and what they did, and number two, was unconstitutional as a violation of the First Amendment. They became even more alarmed in 2001 when the Patriot Act added expert advice or assistance, because they were very concerned that the government might regard they're telling terrorists how to use world resources to advance their claims as opposed to through violence as being expert advice or assistance. So how do you ask people to donate money to your group if you think you might be encouraging them to be violating the law because they're contributing money to something that might be considered material support? So the litigation went on for over a decade and culminated in a case in the Supreme Court called Holder versus Humanitarian Law Project. And if you read this case, the Supreme Court was quite clear about both of the issues involved. Number one, was the Humanitarian Law Project covered by the material support statute for providing expert assistance to terrorists even though they were trying to teach terrorists how not to be terrorists? Of course they were. That's expert advice or assistance. And they had all sorts of theories about how that worked. Number two, does this violate the First Amendment? The Supreme Court says, no, that doesn't violate the First Amendment. They can still advocate. If they want to independently agree with the Kurds and say, we think the Kurds are right, that's fine. But what you can't do under this statute now is you can't do anything to express yourself that is coordinated with the terrorist organization, with the Kurds. This was coordination. They actually were in touch with the Kurds, and therefore, no First Amendment defense. Now, this opinion, as you could imagine, has been highly criticized by First Amendment scholars. But people look at this and they think, okay, well, these were Bush-era prosecutions. This, by the way, was not a prosecution. They were never prosecuted. I just want to point out. They were just concerned about the fact that if there wasn't an injunction or at least a declaratory judgment that this statute could not apply to them, how could they operate? People say, well, okay, so if you have mistakes, that's one thing. Can't we really trust the Obama administration not to bring prosecutions like that? The Sami al-Hussein prosecution, I think one problem is that even though Sami al-Hussein was not himself convicted, if even one prosecution like this is publicized, where you know that you can be prosecuted for posting links to jihadist sentiments, aren't people going to be chilled and deterred from doing that if they're afraid the government is going to prosecute them? After Obama took office, I think a lot of people relaxed about that. A lot of people were very alarmed about George Bush and what he would do and what his Department of Justice would do. And I think everyone kind of assumed that when Obama took office, it was not to worry. They can, they're not going to do things like that. Well, there was a recent prosecution in Massachusetts of a man called Mahana. He was convicted in a trial in December of 2011 of material support of a terrorist group. And in this case, at least the government had a theory about how he actually tried to connect up with Al-Qaeda. No evidence that he ever actually connected, but they said he went to Afghanistan in order to connect up with Al-Qaeda. And he had, of course, a different explanation for what he was doing in Afghanistan. The main activity that Mr. Mahana was convicted of in material support of terrorism was translating various documents that were posted on a website into English. Things about jihad, things about Al-Qaeda, etc. So it sounds pretty similar in some ways, right, to what happened to Samuel Hussein. So he was arrested in 2009. This is on Obama's watch. So the material support statutes can be used, and in fact sometimes are used, to prosecute people for activity that I think we would regard as First Amendment protected activity. This trial, however, took place after Holder versus Humanitarian Law Project, and so I thought the most depressing thing was that the judge charged the jury. Unlike the jury in Idaho of Samuel Hussein, the judge said to the jurors, quote, "You need not worry about the scope or effect of the guarantee of freedom of speech under the First Amendment. You need not worry." And what he thought was, this is covered by Holder versus Humanitarian Law Project. If the jury is given enough evidence to accept the government's proposition that this guy tried to connect up with and coordinate with Al-Qaeda, he no longer has any First Amendment rights. You can't talk to terrorists, you can't coordinate with terrorists. Okay, so I think this prosecution is concerning, and I think it shows you that it can happen even under Obama. And the more important point, I think, is that, as Jon Stewart once said, well, this is okay because Obama will always be president. We've now accepted this new normal, these enormous dragnets. I'll tell you one more story about the material support dragnet and who it can scoop up. I have a picture in my book. I didn't think we had capability here for PowerPoint. I don't know, maybe we would have. But I have a picture in my book of this woman, an Iranian refugee, living in the country under the pseudonym Roya Rahmani. The reason she is living under a pseudonym was that she grew up in Iran under the Shah. And while the Shah was in Iran, she became active with a group called the PMOI. I won't get into the initials or what they stand for. They were a pro-democracy group, and they were trying to depose the Shah, and they were working for democracy in Iran. And she joined them because her dream was that as a woman, she wanted to go to college, and she thought that would be really nice, and that wasn't happening under the Shah. So she supports the PMOI. Well, as you all know, when the Shah left Iran, they did not get democracy. What they got instead was the mullahs, and they got this Islamic totalitarian regime. So after a while of thinking about what was going on, Ms. Rahmani decided to, again, coordinate with the PMOI and work with them to try to depose the mullahs and to try once again to bring democracy to Iran. Well, not surprisingly, the Iranian government had a rather dim view of her activities, and she continued quite courageously to work with the PMOI and distribute literature about what was wrong with the current administration, even though she was watching her colleagues, including her brother, being arrested and killed by the government. Then came the time where she was arrested, and she was sent to an Iranian prison for several years. And when I talked to her, she said at one point, she said, and she was just talking about horrible ways in which she was physically abused in the prison and how horrible life was. And she said to me at one point, and women were fair game. And so I felt like, I didn't even dare ask her the follow-up questions to confirm what she meant by that. So eventually she was released by the Iranian government and traveled to a neighboring country. But she felt that she continued to be under observation, and she was very worried about her relatives in Iran and what was going to happen if she was under surveillance by the Iranian government, which might continue to suspect that she was involved in pro-democracy activities. So she came to the United States. And those of you involved in immigration law know that it's actually a difficult thing to do, but she actually received political asylum because her claim of that she feared reprisals by the Iranian government were really so credible and so well documented. So she's in the United States for 20 months, and she's having coffee at a Starbucks in Los Angeles when the FBI comes in and they arrest her. For what? For providing material support to terrorists. Which terrorists? The PMOI. This group had been designated, and this was under Bill Clinton, not Hillary, Secretary of State, And the idea seems to have been that the Iranian government at the time was insisting that the only chance for rapprochement talks between the American government and the Iranian government would be if we agreed to brand their political enemies as terrorists. So there were things that were said at the time about what the PMOI was doing, whether they ever resorted to violence, but to me, the PMOI looks a lot like the African National Congress. You know, who knows what they were actually doing, but what they're really trying to do is to fight for democracy in their own country, and they're really, who they're threatening to are the government of Iran. Ms. Rahmani had been working for other Iranian refugees to the United States, and she had been working to try to get them methods of supporting themselves when they had fled the regime. And the group that she was working with was connected with the PMOI. Well, under the material support laws, could she make the defense that she didn't intend to do anything to support terrorists, and that even if this group was doing something that at some point was violent and threatened either Iran or even American interests, that she had no interest in doing that? She actually said she was, wiretapped at various points or taped. And there were times where people said to her, well, would you be willing to support violence? And she would say, no, I'm just trying to help refugees. That didn't matter under the material support laws because it doesn't matter. Remember the fungible argument? It doesn't matter what she intends. So what she wanted to argue instead to the jury in her trial in California was she wanted to argue that the designation of the PMOI as a terrorist group was a mistake, that it really was a pro-democracy group. And therefore there was really nothing wrong with her supporting this group. And she wanted to bring her argument to an American jury, just as Sami al-Hussein brought his First Amendment argument to say, are you really going to put up with this? You're the jurors, you're the representatives of the American people. Is it really okay for the government to use this person as a political pawn? Well, the court said to her, and this is inspired by the Patriot Act provision to this statute, no, you cannot challenge the designation of this group. Once the Secretary of State has designated an organization as a terrorist organization, it doesn't matter for purposes of your criminal prosecution whether or not it's accurate. Secretary of State does this, of course, behind closed doors on the basis of who knows what evidence, hearsay evidence, and the designations can be highly political. The African National Congress had been designated. You may recall, remember, Nelson Mandela was on a no-fly list even after he was president. The IRA, on the other hand, had never been designated. It's all just, politics of what's considered a terrorist group and what isn't. Interestingly enough, a number of people, including former FBI head Louis Freeh, began to agitate on behalf of the PMOI that the government was really handling this particular group incorrectly. And quite recently, Hillary Clinton did de-designate the group. She said, oh, well, they're better. They've changed. Now they're a pro-democracy group. They're not doing violent things now. Okay, that doesn't help Roya Rahmani. So again, look at what we have here in the material support law. Once you repurpose the criminal law, not just to be about punishment, about what somebody has done, but about prevention, trying to keep somebody from doing something by allowing government intervention and criminal prosecution at a very early stage, that just gives the government tremendous power to do things behind closed doors. And the argument of the Bush administration that we just have to trust the president, I think is counter-constitutional. So the other example that I want to give you is about surveillance. I'll just give you one example. There are many ways in which the Patriot Act beefed up the ability of the federal government to conduct surveillance on Americans and non-Americans alike. They can do surveillance of American citizens under the Foreign Intelligence Surveillance Powers. As another story I tell in the book, have you heard of Brandon Mayfield, the Portland, Oregon lawyer who found himself being prosecuted, a ridiculous prosecution, ended up in a government apology, but it was enabled by the fact that they could just search everything. The agents were coming to his house and looking at his computer and looking at his children's homework and his client records, all sorts of things. But the story that I want to tell you was about national security letters. So if you were following the discussions in the fall of 2001, you will remember the Librarians, who were among the first people in the country to come out against the super surveillance that was allowed by the Patriot Act in another respect. The Patriot Act allowed the government to go to the secret court, the FISA court, to get an order permitting them to get your records or tangible things or anything that's being held by a third party if the government believed that what they found might be relevant to a terrorist investigation. Not even that you were a terrorist, but they might find something that was relevant. The reason they could do this is that the Fourth Amendment, for those of you who have studied that, says that it's not you don't have a reasonable expectation of privacy in the privacy of your records or anything else if you confide those things to a third party. Okay, the librarian could tell the government what books you've been taking out. There was a case of an FBI agent in Washington State going to a librarian to say, who checked out that biography of Osama bin Laden? Your internet service provider can be required to tell the government whether you are the one who has anonymously posted something to some website, whatever your internet service provider knows about you. Telecommunications providers can be required to tell the government about everybody you've been calling and everyone who's been calling you. This is all under this records held by a third party. Bookstores, schools, medical institutions, hospitals, etc. So enormous power. So librarians were worried about this, and they said, well, this is terrible. We don't want to have to tell the government. The theory is that because we could have told the government voluntarily, the government can make us tell. And the librarians had a lot to say about why this was a problem under the Constitution. So Attorney General Ashcroft at the time told the librarians to calm down because that section was not being used much and was never being used in libraries. It turned out that what he didn't tell the country was that the reason for that was that there was an easier way to get most of this information without going to a court at all. And this way was the National Security Letter, which allows the FBI to issue its own letters with no court at all to say, we want you to give us this information, and furthermore, because we think it's relevant to a terrorism investigation, and furthermore, you can never tell anybody, period. Absolute gag order. Well, there was a case, I describe a couple of cases in my book, one of which was brought by these librarians in Connecticut, the Library Connection, where they get a national security letter, and they were extremely surprised by this because they thought that when Attorney General Ashcroft said, we're not using this, what came to be called the library provision, they thought that meant that their patrons' library records were safe from government invasion unless the government had a real order based on some suspicion. They always accepted that. And they were quite surprised to know that there was this other way of this kind of self-issued, self-help order for demand for information. And then the gag order was very concerning to them because they were told that they weren't allowed to tell anybody. Now that, at the time, seemed to include lawyers. It seemed to include a court. So they actually were brave enough to go to, it was actually a law professor in Connecticut, and ask a couple of questions about this. And they found out that there was a pre-existing ACLU case that had been brought on behalf of an internet service provider. I can now tell you his name is Nick Merrill. But when Nick Merrill got a national security letter from the government demanding information about one of his clients, he was very concerned about this. He had actually been to, was it Haverford? No, it was Hampshire College, sorry. And he had studied the Fourth Amendment, so he knew that courts were supposed to be involved before the government can get information. So he came to the ACLU and he said, now, if I challenge this, is somebody going to put me in a sack and drag me away? And the lawyer said to him, well, we can't really tell you what's going to happen, but, up to you. So he decided to bring this lawsuit, which was called John Doe versus Ashcroft. Then it was called John Doe versus Gonzalez. Then it was called John Doe versus Mukasey. Then it was called John Doe versus Holder. The Attorney General kept shifting over 6 years, and Nick Merrill kept being known as John Doe and was not allowed to tell anybody that he was the person bringing this lawsuit because he was under this gag order. The government tried to make the ACLU not mention the existence of the lawsuit on the ACLU website on the theory that that might compromise national security, but the federal judge in New York wasn't having any of that. And in fact, the federal judge did find that this absolute permanent gag order on everybody was a bit excessive under the First Amendment. Nick Merrill, like the Library Connection of Connecticut, always got that they shouldn't tell anybody who the government wanted to investigate, that could be a problem. You didn't want to share that information and wreck a government investigation. But the government was taking the position that they were not allowed to even say that they had ever received a national security letter or to talk about that experience. So both Nick Merrill and the Library Connection people in Connecticut wanted to testify before Congress the first time that the Patriot Act provisions involved were up for renewal. This is now 2005, 4 years, and these provisions were supposed to sunset, some of them. The government said, you're not allowed to do that. You can't tell anyone that you have received a national security letter. The Library Connection people said, but the American people and Congress have the right to know that when Attorney General Ashcroft says your library records are safe, they're not safe. The government can't get as much information under national security letters, but they can sure get a lot, and they're not even going to a court, and we think Congress should know that. Department of Justice said no. Well, there are a lot of very amusing stories about all the secrecy in these cases and how that worked, which in the interest of time, I will not tell you now. But the upshot was that the Southern District judge did find that the absolute gag orders violated the First Amendment, and Congress made a very minor change. They did recognize that they should not apply the gag order to your ability to talk to a lawyer or to go to a court to argue that a particular national security letter was too burdensome. Now, while the library connection case in Connecticut was pending, there was a Washington Post reporter who, for the first time, reported on this whole national security letter situation. And what he reported, and that nobody knew at the time, was that not only was this a procedure that was being used in libraries and telecommunications providers, internet service providers, but it had been used on hundreds of thousands of occasions. Hundreds of thousands of these demands had been made with no court. Just tell us and never tell anyone. Most people never told anyone because they took that gag order quite seriously, or they were cooperating. And we have had, at this point, there are like 6 or 8 recipients of these hundreds of thousands of demands who have wanted to do anything about it. So you ask again, well, what's wrong with this? Shouldn't we just trust the government? In 2007, the Inspector General of the Justice Department did a report on the use of national security letters. And what the Inspector General reported was that behind the closed doors, believing that there was no oversight and that nobody was watching what was happening with the national security letters, the FBI had violated its own internal regulations on thousands of occasions. They had gotten really sloppy. Instead of even filling out national security letters, they would send a post-it note to various telecommunications providers saying, hey, give us the information. They had representatives of Verizon working in the FBI office and drafting the national security letters and being right there to help them get all the information. So this finally did come to a hearing in Congress, and the FBI counsel at the time said, yeah, I get it, this is an F report card. We'll try harder, we'll do better. But to me, it's a real example of what happens when you agree that the just trust us power is all going to be exercised behind the scenes with no oversight and no public intervention. Well, I want to give you 2 updates. Update number 1 is that we have had a couple of other information providers who have since then decided to try to challenge the national security letters. The Electronic Frontier Foundation represented a small telecom based in San Francisco. It is believed, although they have never confirmed, that the group is called Credo. And in March, a district judge in San Francisco ruled that, it was March 14th, ruled that the national security letter provision is unconstitutional because of the gag order provision. She held that it violated the First Amendment, and she found that that was not severable from the rest of the statute. So she said she was going to enjoin the application of this statute, but she allowed the government 90 days to appeal. So almost certainly they will appeal, although Obama, when he was a candidate, said no more national security letters spying on Americans. Now that he's the president, he thinks national security letters are just fine, and the rate of usage is about the same as it was during the latter part of the Bush administration. So that was the ruling on March 14th. We still don't know the identity exactly of the telecom, although we have reason to believe that we probably do. But the most interesting thing that happened just last week, on April 3rd, was that we now have a new participant in the lawsuit in San Francisco, who you've heard of, Google. Google has decided to challenge the national security letters, and what they say, they had to fill out a form, and they say that they receive between 0 and 999 national security letters annually. So they have asked to have the legal process set aside. They've also joined this lawsuit claiming that the national security letters are unconstitutional. Now, 2 interesting things about this litigation. Number 1, when the first lawsuit was brought, the one that was probably brought by Credo, what the Department of Justice did was they counterfiled a civil suit. This is the Obama administration now, not during the Bush days. They counterfiled a civil suit saying that it was illegal for whoever this telecom was to bring a lawsuit challenging the national security letter power. They said under the revisions, what you're allowed to do is you're allowed to challenge the gag order in an individual case and say, we think it's okay for us to tell certain things. And you're allowed to say this particular national security letter is too burdensome, but you're not allowed to challenge the constitutionality of the whole program. Okay, so anyway, there was a lot of negotiation, and the government agreed to stay their civil proceeding, and they're now arguing just within the San Francisco case about whether or not providers can be compelled to turn over information like this. So stay tuned on that one, very current recent developments. One thing I think is quite amazing is that out of those hundreds of thousands of national security letters, that we've had only about a half a dozen recipients of these demands come forward and challenge it all. So there are a lot of other things I could talk about, the Muslim charities and so forth, but the one thing I think I want to mention is that in addition to talking about rights and the whole problem with our rights being violated or our rights being shrunk, there's also been a problem with the checks and balances here. I have many stories in my book about how people have tried to bring challenges in court about First Amendment violations, Fourth Amendment violations, and in most of the circumstances, the courts have batted away the challenges on standing ground, like this term's decision in Clapper versus Amnesty International, if you know that one, state secrets privilege, immunity, just all sorts of procedural excuses for the courts not to consider whether or not a lot of these dragnets violate our rights. So the courts have kind of read themselves out. The courts have only taken cases where the government has lost in the courts below. They're not interested if the government has won. They leave it alone, the Supreme Court. Congress has been more or less a rubber stamp on this. The Senators Wyden and Udall, who are both on the Senate Intelligence Committee, have announced several times in the past couple of years that the Obama administration has an interpretation of the, quote, library provision and of its surveillance powers that would shock the American people if we knew. So they've mentioned this several times. The first time they did, Senator Feinstein said, oh, maybe we should have a hearing about that. Hasn't happened. So Congress is not really being much of a check either. I think I want to close before we go to questions by reading you a quote that I really like from Elaine Scarry, who writes well because she teaches English at Harvard. And it's all about, the title of my book is not just about rights, which I think some people have thought about the rights, but about, in fact, the impact of all this on American democracy. What happens when those librarians are not even allowed to talk to Congress about their experience? So here's what Elaine Scarry says about the Patriot Act. She says, the Patriot Act inverts the constitutional requirement that people's lives be private and the work of government officials be public. It instead crafts a set of conditions in which our inner lives become transparent and the workings of the government become opaque. Either one of these outcomes would imperil democracy. Together, they not only injure the country, but also cut off the avenues of repair. That's where we are now. I think people have stopped worrying about all of this. Finally, we are getting some attention to torture, to targeted killings again in connection with the confirmation hearings of Mr. Brennan and so forth. But again, the reason that I wrote this book is that I think that democracy starts in rooms like this. And it starts with people knowing more about what the government is doing so that we can know whether or not we're acceding to a new normal. So that I think there is an impact, a present impact of all of this surveillance and the material support statutes and all sorts of other things that I talk about in the book. There is a present impact. But if we had a change of administration, or if there were to be another terrorist incident that got people upset, we would see all of these dragnets being used a whole lot more. So I thought that when I wrote the book, it was 10 years after 9/11, I thought even though you can understand how in the panicky days right after 9/11, maybe Congress would have overdone it, or maybe they would have aimed in the wrong direction because we didn't have a diagnosis yet of what the problem was. We didn't really know what had happened, so it's hard to know what the antidote is. But 10 years later, I thought it would be a very good time to start a conversation about whether or not we were right about all these things and whether or not we want to rechart our course. So I want to thank Mr. Palmer again for the opportunity to talk to all of you and for trying to bring attention to these very important questions. So, should we go to questions? Questions? What would you like to talk about? You can applaud yourselves too after you've done questions. Sir, in the back.
So you mentioned that at least with respect to the domestic side, there's been no difference between the Obama administration and the Bush administration, despite candidate Obama and Senator Obama's speaking out for civil liberties. To what do you attribute that? What,
I'm sorry, they slammed the door. Was the end of your question?
To what do you attribute
To
that?
what do I attribute that? Okay, I attribute President Obama's change of position to his change of position. He became president. Some people say, oh, well, that must mean if he's not changed anything, that must mean that now he knows the secret handshake. and he must know that these are the things we need to do to keep us safe. I think the interpretation is really otherwise. One thing that's very frustrating researching this area is that people within the government say, oh, well, this is all the stuff we have to do, it's keeping us safe. And there's no way to evaluate that because we don't know, what's been foiled or how, or, it's very hard to evaluate. I think that the chief change in President Obama is now that he is wielding all the dragnets, he trusts himself. Okay, it's human nature. Of course you trust yourself to have too much discretion. And I think a lot of people worried while it was George W. Bush, and it was very ad hominem worry. They were worried about George W. Bush and his judgment, or Dick Cheney, or Gonzalez, or whoever. But to me, the Constitution is not ad hominem. It's not about who the individual is. It's just that, as the Inspector General report on the national security letters show, you let the government do too much in secret. And it's just a problem. I think we're having the same thing about the drone killings right now. It's all going on behind closed doors, and President Obama says, well, just trust me. I don't want to kill anyone who's not a terrorist. I believe that. I believe he's a good man, but I think we have checks and balances for a reason. And so I'll tell you the last comment I sometimes make about this change of position, the just trust me. I said to somebody recently that I think that what President Obama needs to do is to read about Frodo Baggins, right, in The Lord of the Rings. Sometimes, even if you have this enormously powerful weapon that you would really like to use for good because you think that you're not going to be safe unless you use it, sometimes the right thing to do is not to use it. Yeah, go ahead.
Two questions. One is, what happened to Roya, the woman you were
Roya?
thinking of? And secondly, this is all so distressing. Do you think there's any hope?
Okay, what happened to Roya? The last I heard, she was still in the process of appealing her conviction on First Amendment grounds, trying to argue that. I actually don't, I had just tried to get in touch with her lawyer quite recently to say, so how's she doing? And I hadn't heard back from him. I don't think that the fact that the PMOI has now been delisted would help her because they started the prosecution before, although I don't know. So I hope she's doing all right because, my God, what a life.
Do you know what she was sentenced to?
Do I know
what her sentence was?
I'm sorry, I don't remember. It's several years now since I talked to her. Sorry. So in terms of any hope, okay, well, here's the problem that I think we have. It's sort of like, and again, this is sort of what some people say as well, if the courts and Congress and the president are all pretty much in agreement on this, isn't that a sign that they're right? And I think what we're getting is an echo chamber. The courts are not doing any independent research because you don't have standing, and this is the state secrets privilege, and you have immunity. And the courts, believe it or not, have not reached the merits of a single challenge to any torture or extraordinary rendition claim. Every single claim they're just thrown out. And it's been pretty much the same. There are some exceptions in the surveillance area. There are a lot of provisions of the Patriot Act that the ACLU tried to challenge, and the courts just batted them away. So a lot of people say, well, doesn't that really mean we don't have a problem? I think it means we have a greater problem. Because I think what happens is that once the president says, or once we start out in the fall of 2001 saying, let's do this, let's assume that there's this Brooklyn Mosque to Al-Qaeda pipeline which we need to shut down. Or let's assume that if we just get more and more and more and more evidence in the data banks that that's going to make us safer. It doesn't if we don't have the algorithms to figure out how to find terrorists out of all that information. But I think the problem is that everyone wants it to be true that the president knows how to protect us. Plus, at that point, you get a lot of vested self-interest. We have, at this point, we spend more money on national security than all the other countries in the world combined. And if you read, people talk about the military surveillance complex at this point, we have the most incredible amount of information sitting in data banks. That is an entire industry. There are a lot of government employees who are making a living out of collecting all that information. Some of it is civilian, some of it is military, some of it is contracts with private companies. You could ask the interesting question, who's profiting by all our anti-terrorism efforts? And so I think you have this natural tendency of the branches of the government to go in lockstep. And it's a real problem. Again, we've finally gotten a little bit of public traction on the targeted killings issue and on torture. The ACLU has been trying for years to get somebody to pay attention to what we're going to do about our very sorry record of torture and extraordinary rendition, mostly during the Bush years, but perhaps not exclusively. And President Obama said, well, let's just turn the page. Congress didn't have hearings. There were no special prosecutions. The couple of very low-level soldiers like Lindy England got blamed for everything. And we have not come to terms with what we accepted as a society. So I think it's a real uphill battle, because I think at this point there is no branch of government that's interested And Glenn Greenwald, I thought, had a very astute point, which is that during the Bush years, the Democrats in the Senate were fighting the Patriot Act and fighting the centripetal force of all the power going to the president, because that was to their political advantage. Once the president became a Democrat, it was no longer to the political advantage of the Senate Democrats to complain about what the president is doing. Therefore, there is very little challenge because of the way the political interests align. So, am I optimistic that a lot of this is going to be changed right away? You know, I think you can't be optimistic. But I think what we have to do, as I said, democracy starts in rooms like this. And the more people who are aware of what's going on, I think the better chance we have to keep these issues alive and to hope that at some point, you know, we'll get some more attention. You know, how long did it take after World War II for us to apologize for interning the Japanese Americans? It took 40 years before there were reparations and an apology. Alabama just apologized for the conviction of the Scottsboro boys in the 1930s. Okay, they finally, you know, pardoned them. Yet sometimes it takes a long time. But the problem with this whole, you know, war on terror idea is that it's so indefinite. We don't know how long it's going on. But again, what I want to impress upon all of you is that this is us now. And this is not like a wartime measure where it's just temporary and then the war ends and we go back to normal. This is becoming our normal. Do we have time for one more question?
Last question.
Last question. Sir.
Well, I survived World War II in southern Greece during the Nazi occupation, and now in my old age I'm going through a more severe Nazi occupation by my own government here in the U.S. And I'm a lawyer myself, and I talk to lawyers, I talk to academic people, and they look at me like I'm crazy, and you become persona non grata if you question the whole premise of all these things that are happening, which I admire you and I applaud you. Your expertise is superb, and your heart is in the right place. But you know, many people in the law profession, intellectuals, professors, and so forth, they are into the government prefabricated conspiracy theory about September 11th, which I myself, not having read much about it, but just as a plain person, I can see that 19 guys could not decide to commit suicide at the same time. Maybe one or two might decide. But people who come from everywhere and say, oh, we're going to commit suicide today with airplanes. Number two, people who don't know how to fly those airplanes cannot be suicide bombers. Number three, when the bridge fell, maybe I'm the only person that brought this up, in Minneapolis, St. Paul a few years ago, they said we're going to do a forensic test. We're going to take all the debris and take it, and scientists and engineers and chemists are going to check it and find out what the problem was. Then September 11th, they took the things and they discarded them somewhere. No forensic examinations, nothing. And the last thing is, how many people that were killed on September 13th were CEOs, chairman of the board, or vice presidents? I saw just a lot of different people of our nationalities and religions get killed, but they were all low and middle income office workers. The president, the owner himself, on Charlie Rose said, Charlie asked him, Mr. Silverman, I think his name, where were you on September 11th? He said, well, Charlie, my wife reminded me the day before that I had a doctor appointment. Now, on Charlie Rose, I'm going to finish with this. Things are going to get worse. Ted Koppel, several years ago, he got on and he said, Charlie, you know, there's going to be it's not when, it's if, it's when. The next terrorist event is going to be worse than September 11th, and then we're going to have no more habeas corpus, lifetime detention, no trials, and he sits back cavalierly says, and we're going to torture. Who's we? Who is he speaking for? Is he speaking for us collectively, the American people? And so I say it's worse to survive now than it was during the Nazis, which millions and millions of people survived. At that time, there was hope. The Russians were going to defeat the Nazis and lost 27 million. Now there's nobody fighting the Nazis. The Nazis are going to countries and killing one leader after another and then enslaving the country.
Okay, let me sort of pull back from your point and generalize in a different way. I think, you know, what I get from some of the things that you're saying, a common theme in what you're saying and what I'm saying is that there are not that many people at this point talking back to the government. And there are a lot of different things on which, of course, people might want to say to the government, we disagree about what happened on 9/11, we disagree about what you're doing. What I do not counsel, you were asking me how optimistic am I that any of this is going to change right away. I don't see the political wherewithal to have a lot of change right away, but that does not mean that we should stop talking. As the ACLU likes to say, the job of a patriot is to keep your mouth open. You know, dissent is patriotic. So I think that the president, one reason why President Obama is taking the positions that he's taking is that most people are saying to him, you go ahead and have all the dragnets you want. We want to give you every power that keeps us safe, because what if there's a terrorist and we can't find the terrorist without these supersized surveillance programs? What if there's a terrorist and we can't prosecute the terrorist and lock him up because we don't have enough evidence? What if there's a terrorist who's hiding there in Yemen and we can't bring him into court and try him? Therefore, the ACLU position is not from the side of what if there's a terrorist, because that dragnet thinking leads you to, as we all know, you lay out a big enough dragnet and you get a lot that you do not intend. And I think you're doing a lot of damage that you do not intend. So my point of view is, well, what if there are a whole lot of innocent people and you are sweeping them up in your dragnet because your dragnet is too big and you're not insisting on enough due process? What if there are a whole lot of people who are going about their business and doing things that they would just as soon have the government not know about for their own personal reasons, and they're not terrorists, and the government is scooping up all of our conversations and finding out everything we're doing? So the question is, even if there's no reason to be optimistic immediately that all this is going to change, does that mean we should stop talking? I think we have to talk more, those of us who believe that there may be, at least we want to question whether or not we're doing the right things. I'm not saying that everything in the Patriot Act is wrong. I'm just saying that after a decade of having done these things, which we know have consequences in terms of rights, the 9/11 Commission said the executive branch should have to defend keeping these powers. They should not just become the new normal. So I think I want to tell you one final anecdote along the lines of Margaret Mead once said that a small group of committed people is all that has ever affected change. There are two lawyers in the ACLU office, Jamil Jaffer and Amrit Singh, who were talking about what to do about all of this. And one of the things that occurred to them in the fall of 2001, one of the problems that we had was we didn't know who the government was detaining as suspected terrorists. We knew that there had been a lot of roundups on the streets of New York, just pulling in people for immigration violations. Nobody knew how many, nobody knew where they were, etc. So Jamil and Amrit were talking one day and they said, well, what if we filed a Freedom of Information Act lawsuit? And what if we said to the court, you make the government tell us some of this information? What are you doing with national security letters? What are you doing with targeted drones? That wasn't at the time, but we've become specialists on freedom of information. So they had this idea, and they went to a senior lawyer in the office and said, what do you think? And the lawyer, having been around a few years, said to them, oh, come on. You really think any court is going to order the government to turn over information if the government says turning over this information is going to threaten our national security? He said, I'll give you a nickel for every page you get the court to order released. Well, Jamil and Amrit went ahead, and I am happy to tell you that hundreds of thousands of pages later, that lawyer had to renege on the bet. So I sometimes say to law students, never doubt that was two people, and they changed the world. Among the documents that we got because of ACLU Freedom of Information Act lawsuits were the Office of Legal Counsel memos defining torture. We found out a lot of information, not everything we would like to, but that's the beginning. Individual people can, in fact, hold the government accountable. You can do it in your own way by writing to people who you vote for and say, don't just assume I'm going to vote for you if you support things and never ask questions about whether we're doing the right things here. So again, thanks so much to Dean Krent, to the law school, and to Roy and Susan Palmer for giving me the opportunity to talk with you. I hope that you all want to buy the book. I'm happy to sign the book, special inscriptions for ACLU members. Thank you.